My name is Kolvin Stone, and I'm a partner and head of technology at Fox Williams. So ransomware attacks are on the rise, and we've seen a number of law firms and also barristers' chambers affected by these attacks. Even the past week, we've seen a law firm, Keller Lechner, have to respond to press commentary about a data breach that it suffered. Ransomware attacks and data breaches in general are serious and business critical issues. So we are delighted to be able to offer this workshop to help you understand some of the key initial steps and the issues that you need to take to deal with an attack. Responding to incidents which place the firm in jeopardy is so much more than a technical problem. It's a business problem that involves senior management, in-house and outside counsel, insurers, incident response and security specialists, crisis communication agencies, and your internal IT teams and business resources. So to reflect that, we have a range of industry experts helping us today with this workshop. And what we're going to do is we're going to walk through a sort of typical life cycle of an attack. It doesn't always follow in the sequence that we outline, but broadly, it is kind of sequential. So next slide, please. So firstly, we have Arno Roberts, who is the CEO of ITC Secure, which is an advisory-led cybersecurity services company. Louise Beeson, who is a senior consultant at Bell Yard Communications, and they specialize in litigation PR and reputation management for the legal sector. So perfect for today's workshop. Daniel Sutherland, who is our head of professional services at Fox Williams. Nigel Miller, who's our head of data protection at Fox Williams. If you have any questions, please feel free to pose them using the Q&A function. And if we have time, we will try to deal with them at the end. If not, we'll follow up separately. So next slide, please. So often attacks involving information and also IT systems really start as a security incident. So attacks often always look the same at the beginning. So nothing is working, or maybe parts of systems aren't working. And it takes a while to really try and work out exactly what is happening. And it's often maybe the staff that perhaps notice first, depending on exactly when the attacks happen. We've seen a few attacks happen on a Friday night or early Saturday morning, which is incredibly disruptive. So next slide, please. So Arno, at this stage, it's really the IT team that are dealing with the attack. Could you sort of outline for us how a security incident typically unfolds, and what would the IT team generally be doing at this stage?
Kolvin, thank you very much. And really, at this stage, all we have is an IT incident, as you said, and it really is no different to a faulty printer. I mean, the number of requests the IT team get that somebody's computer isn't working is plentiful, and often that's the first problem. That's the first hurdle that businesses face, because there's valuable time that is lost at the beginning of a potential serious incident. So the first thing we would always recommend is that businesses adapt their IT incident or IT support reporting, internal reporting to the IT team, that there's a difference between a potential cyber breach or data breach or data incident and a faulty printer, to make sure that it very quickly gets the right level of attention and gets dealt with appropriately from the outset. Then what we're looking for here is that hopefully the IT team are prepared for dealing with incidents. And the most common issue we see here is the IT team overreaching early on in a potential incident. They need to know what are their parameters of operation, what are they allowed to do, what they're not allowed to do, and when they need to consult with experts. So hopefully that's, as we'll get through the incident, that's we'll see the importance of planning and documentation and testing that in advance of a potential incident, and the value that would have. Very important briefing for the IT team is from the outset, even from this basic initial IT incident, is to think about what the regulatory obligations might be. So we don't know anything yet. This is still just an IT incident, but from the outset, they should be thinking, is there personal data involved? Is there banking or financial data involved? Because that'll inform the decisions we take later on once we know more.
Sure. And are there any initial indicators that you see right at the outset that points to this being serious, or is it at the very early stage always difficult to tell whether this is a serious incident or whether it's an external actor?
What we see is, because ransomware, as you say, is rife and continuing to escalate, and is the number one attack the businesses are facing. It's been all over the news. Every person almost can easily identify a ransomware attack. You're logged out of your computer. There's a screen with bright colors demanding money. So that we see is quite quickly identified by the user, and typically very quickly escalated in IT. Some of the more sophisticated attacks are more difficult to detect. A sophisticated, well-executed attack, no user will ever know. So it's unlikely to come from a user raising an escalation or an issue, and more likely to come from your information security team monitoring your systems, either through technical monitoring, so seeing big amounts of data leaving the organization, or with some more sophisticated monitoring, looking at what is the typical behaviors inside the business and identifying deviations beyond that. And I think the important thing to note there is that the attackers don't have office hours either. They would most commonly be in different time zones to us, if I may generalize. So it's very important that there is someone, or there is a service provider helping an organization 24 hours a day monitor their systems, particularly now with the amount of cloud or publicly available systems. These systems are online permanently and therefore accessible around the clock. So our monitoring should be covering around the clock too. And so most commonly, that's where this incident would come from if it's not ransomware.
Yeah, okay. Next slide, please. So typically after it's been determined that there is something, either part of a system is not working or nothing is working, that a ransomware note is found. Next slide, please. Okay, so Arno, with this new information, it's you found a note, it's a ransomware attack. What would you be typically doing now?
So again, to confirm for everyone who's been fortunate enough to not have to deal with the ransomware attack, but ransomware is a malicious software application that spreads automatically inside a computer network. So it'll self-propagate and spread to every possible device it can access. It will, in its most basic form, encrypt that device, therefore rendering it unusable and inaccessible to the user. So that's why even minutes are very important early on identifying the incident. Typically what we've seen is businesses have now broken out ransomware incident response plans from the usual incident response, and actually has a special plan that can be executed by IT much quicker, because the easiest defense in the early parts of a ransomware attack is to disconnect the systems that have not yet been affected. So physical offices, different data centers where the information may be stored, cloud access, and very, very important is your data backups. Every business will have, even just for regulatory obligations, will have a level of data backup. And hopefully, as part of that preparation, it would have been set up in a way that the ransomware can't get to it. Unfortunately, too often we see ransomware spread into an organization and actually spread all the way into the backups. So the backups are completely encrypted too, and therefore rendering it completely useless. So that's helpful in terms of its preparations. as ransomware is confirmed, we would then move into the next phase and actually invoke our incident response plan. Very important here is that incident response plan expands the escalation and the communication between the IT team, beyond the IT team. Very important that it's not just IT or even in cybersecurity experts making the decisions. You need a team that is representative of the necessary individuals across the business, typically legal, typically internal and external communications. But that's very important. Step one is who's involved, therefore, of the plan. Step two is how are we going to communicate? Often in the case of ransomware, we see businesses locked out of their email. So that's not an option. They're locked, the employees are locked out of their physical corporate devices. So they can't log into anything else to communicate. And the incident response plan should have taken that scenario into account of how are we going to communicate as a team, then to our employees, and eventually externally. That may be difficult. The plan is not prescriptive. It can be adapted on the fly, but very important that proper preparation and planning prevents poor performance. And time again, we've seen it that companies that have plans in place, companies that have done cyber incident response tests of their plans or business continuity tests, inevitably handle the situation better when it does arrive or arise one day. So that would definitely count in their favor. An important first call that I think many people don't think about, or not one of the first calls should be to your insurer. Many business insurance policies will have a cyber insurance clauses in it, both to help the business understand what they may be covered for or not, but also some insurance policies are quite prescriptive about what steps you should take. Some even have preferred providers. If you need deep cyber forensics in, will have approved lists that you need to engage in order to be able to claim that back. Most modern cyber insurance policies actually also cover payment of the ransom. That becomes a business decision, obviously. Are you willing to pay a ransom? It's funding organized crime. It's driving more and more crime and clearly not going to a nice place. But we have seen that most commonly these days, businesses pay the ransom, they get the data back, and it's the quickest way to get operating again. These are all decisions that hopefully you're able to consider when you're not under pressure because of your planning and your preparation. Agree a business line and a business position so that you know when you're under pressure what direction you'd want to be going in. So right now, our focus would be on containing the spread of the ransomware. Then we'd like to move into recovery, getting the business operating back to normal, and then we'll get into investigating much deeper into what happened.
In terms of investigating and preserving evidence, Nigel, why is it important that the IT team are directed to preserve evidence such as server logs?
Thanks, Kolvin, and hi everyone. Yeah, so in response to a cybersecurity incident, the inclination naturally is to try and get the issue fixed as a matter of urgency. It's the priority, and that's perfectly understandable. But if the sole focus is to recover from the incident as speedily as possible, evidence could be lost, which might be needed at a later date. So why might it be needed? Well, it may be needed either to bring a claim against a third party who might have some responsibility in relation to the incident, or it could be needed to deal with any claims that could be brought against the firm, or it could be needed for possible later discussions with the ICO about how the incident happened. So you should therefore consider this need to gather information and forensic evidence about the incident, which may be needed later on, accepting that could cause some delay to the recovery a little bit, but it could be important depending upon the circumstances. So before restoring a server from backup, for example, you could image the server and all relevant log files to ensure that the original data is preserved and is not overwritten or changed in any way. But a word of caution that collection of digital evidence has to be handled correctly to ensure the integrity of the evidence. This probably requires the support of a specialist digital forensic professional to save whatever evidence there may be in an auditable and reproducible form. There is a good practice guide for computer-based electronic evidence produced by the Association of Chief Police Officers, which sets out key principles for collecting forensic data. It provides, for example, that no action should be taken that might change any data that may subsequently be needed to be relied on as evidence in court, and that an audit trail is kept of all actions that are taken in respect of the digital evidence, and that audit trail is preserved.
Thank you, Nigel. So at this point, we know it's a ransomware attack. We know that systems are affected. Maybe all of our systems are affected. We know that employees will be aware that something is going on. So, Louise, if I can turn to you and just ask you, what should we be doing about our staff? Because they're often the sort of first cohort of individuals that will know that something is going on. What should we be telling them at this stage, and how would we, do that, assuming that maybe all of our systems are down, like Arno said, and emails down? What would you suggest in this scenario?
Thanks, Kolvin. Yeah, I think first of all, obviously, we need to assess to what extent the employee user interface is affected. It may be that only one division or one practice area, or it may be the whole firm's Windows applications have gone down, and obviously that will determine the communications that you give. If it's possible early on, I would try and avoid using dramatic language. So issues, challenges, IT difficulties, rather than ransomware attack, because that is obviously dramatic and sets hairs running. But if it is an incident of scale, then the practical steps are that you will need to move employees to a WhatsApp-based kind of communications channels, make sure that line managers have everybody's mobile numbers. It may be that you have to walk the floors if people are in the office, if it's not a Friday night or a early Saturday morning, and verbally explain to people what's going on, give them letters as you ask them to leave the building. And the practical important things are to tell people that you will communicate with them regularly, and when and where and how they can expect to receive that communication. Advise them if they want to move to personal email, for example, to continue their work, that there's probably a protocol and a procedure in place so that they can only do that with client consent, or then there might be data transfer protocols if the main systems are down. There may be an alternative workplace they can go to. And it's important to remind people that there will be a firm-wide kind of response and official communication to any clients impacted, and to any obviously incoming calls from clients and or other external parties like the media. So you don't want people to be speculating unnecessarily, but you were committed to keeping them informed, but just making sure that they know where and how they can receive that information.
Presumably as well, it would be important. I think you sort of started to mention this, that there might be some external communications at some point. So presumably they should be told under no circumstances to talk to any press inquiries or talk to any client inquiries at this stage. So confidentiality, I imagine, is quite important when you're telling the employees. Absolutely.
So as I was saying, I think that the firm will deal with the communication to clients and to the media that's required, and people should refrain from speculating or indulging in unhelpful communications when they don't have the official line.
Yeah. So Nigel, is there Arno talked about potentially notifying insurers. Is there anyone else that we would be considering notifying at this time, or is it too soon? We're at the early stage of understanding that we're subject to a ransomware attack. What is there? Anyone else you think we should be notifying or considering notifying and starting some planning?
Yes, absolutely. So Arno's mentioned about the insurers, and it's good to get them on board quickly, not least because if we don't, they may possibly reject the claim if, for example, we've already incurred expenses that they don't approve. But in terms of other notifications, just focusing on the legal obligations that we have under the GDPR, UK GDPR, because we're dealing here with a data breach, in all likelihood, if the data has been compromised, then we have to consider the obligations under the GDPR. And that says that a data breach has to be notified to the ICO, and in certain cases also has to be notified to the individuals whose data has been affected. But it's not always the case that you have to notify. You don't necessarily always have to notify the ICO. It really depends on the risk assessment around the incident that you make. So in terms of timing, the GDPR requires that a data breach is notified without undue delay and, where feasible, not later than 72 hours after having become aware of it. So that time begins to run from when you have a reasonable degree of certainty that a security incident has occurred that's led to the data being compromised. So when you first find out about a security incident, you may, as we've discussed, not really know what's going on. So there is a bit of time allowed to carry out this initial investigation in order to establish whether there's been a breach affecting personal data or not. During this initial investigation period, you're not regarded as having been aware of a breach. So the clock hasn't started to run, if you like. The initial investigation should obviously begin as soon as possible until you get to the point that you've got reasonable degree of certainty that a breach has taken place. So although the clock isn't ticking on the 72 hours, it's important to carry out this initial investigation first to ascertain the facts as far as possible, and then that'll enable you to decide whether or not to notify the ICO and affected data subjects, whether that's required or not. I'm sure we'll come on to that shortly. In terms of anyone else that might need notifying, you are encouraged to notify Action Fraud, which is an online portal for making that notification. It's entirely voluntary, and in most cases, it doesn't lead anywhere other than them keeping a record for their own statistics. You may also just give some thought to whether you're under any contractual obligations to notify third parties that there's been a data breach. Sometimes that arises if you're, for example, a data processor or involved in any data sharing arrangements where there's mutual obligations to notify the other party to those arrangements that there's been a data breach. So it might be time to consider what contractual obligations you've got as well.
It's probably worth highlighting that at this point, we may not have any evidence of any exfiltration of data. But a ransomware attack leads to a loss of availability of data, and that's also a breach, isn't it, Nigel? It's not just, people often think of a data breach of data has been lost or it's been disclosed, but the concept is much broader than that, isn't it?
Yes, absolutely. So it might be confidentiality if data has been accessed or taken, but it will necessarily involve availability issues because you might not be able to access the data either at all or for a period of time, which could cause problems. So inability to access data, or where data has been deleted, which might include where data has been encrypted, would be an availability issue, which would be classified as a data breach.
Nigel, next slide, please. Okay, So I think we jumped a slide. Okay, sorry, next slide. Right, sorry, thank you. So Arno, we've confirmed that we've got a breach and the incident response team have been convened. So what does a sort of full investigation start to look like?
Certainly, Kolvin. So at this stage, we'd hope to think that we've managed to contain the spread of the ransomware. As Nigel pointed out, very important that the business considers the trade-off between recovering operations versus preserving potentially useful and critical evidence. And again, very important, do not let the IT team make that determination or that decision. That's a business decision that the business should guide whoever's doing the work on what the priority is, what is the objective. Let them execute, but let the business decide based on risk, based on cost, and the other factors that there might be. As we now go down into the deeper investigation into what happened, who may have committed it, and where has the data gone, this typically goes beyond the experience and the capability of any internal IT team, and that's typically where you would engage an external partner, either recommended through your insurer or preferably a specialist cybersecurity firm that you may already have on retainer. That's typically the best approach of businesses to take. For a modest annual investment, that means the firm comes in and helps you as a business prepare. They would prepare documentation, they'd prepare planning, they'd run you through testing, they would build up a familiarity of your technical systems and how you operate, meaning that when you do have to call on them one day, they're able to help you recover much quicker. By having them on retainer, you also have guaranteed response times, and you have guaranteed availability from them. And also critically, you have preferential rates. If you approach somebody in your moment of crisis, it can exacerbate the costs. What we see is what you should expect as well as a business is, if you don't use any of their services on an annual basis, they typically give you a rebate on your retainer too for user awareness training or for other aspects of it. So that's an important factor to think about. Some of the large organizations that we support that are very complex environments and that operate in multiple jurisdictions will have multiple specialist incident response firms with different skill sets, different availability, etc., on retainer. So that's definitely something to think about. Our investigation is really focused on establishing the root cause, what went wrong, what devices were affected, what data was affected. As Nigel said, once we confirm, and if we confirm that personal data is involved, then clearly there is the GDPR or the UK interpretation of that kicks in, and we have the 72 hours to report that. I think it's important to understand that the regulator is not expecting you to have all the answers in those 72 hours. I've not been involved in any incident where all the facts have been known, but it's important to let the regulator know that you become aware of something. The more information you can share with them, the more you know, and the more you can show that you have the situation under control and that you're taking very considered action, the more the regulator will be at ease, we find, and the more freedom that they give you to continue your investigation and to continue recovering your systems. As part of establishing the root cause, specifically for something like ransomware, what we'd be looking to do is to establish what type of ransomware is it, and who typically uses that type of ransomware, because that'll inform us and give us information we can bring back to the business and bring it back to the incident response team that may inform, have there been other instances of this ransomware where people have paid the ransom and actually got the data back? Do they pay it and they don't get back? All these different factors could be known once we determine the type of ransomware. In the UK, there's an information sharing partnership called CISP, the Cybersecurity Information Sharing Partnership, run by the National Cybersecurity Centre, the NCSC. This is a free to access portal for all UK registered companies, and that has shared threat information. So both shared by government based on for example, ransomware that they've seen, different attack groups using it, signatures, ways of identifying it, but also all the participants, other UK companies, can share information about attacks that they've observed in. So this is a very useful portal. It's free to access, as I mentioned before. All you need is to be referred or be recommended. So if anybody's interested in that, please do contact me afterwards, and we can we can refer you in, but that's free to access and a very good resource to have to help inform next steps around ransomware and whether we pay the ransom and what position that might give us.
Great, thanks, Arno. And so at this point, we are carrying out a sort of comprehensive investigation. So, Daniel, at this point, certainly from the legal perspective, we're starting to think about how we perhaps maintain privilege. Can you just outline the sorts of things we should be doing to maintain privilege and why that's actually important?
Yeah, thank you, Kolvin. So I think at this point in the scenario, clearly the focus is going to be quite inward looking, getting the firm up and running, trying to recover. But I think at this stage, you do need that look ahead to the future where really questions may well be asked, both by your clients who may be affected by the discontinuity of the service, and indeed by a regulator who may want to ask the question, did you do everything you should have done, both in the situation and to avoid the situation having arisen in the first place? And so the firm will want to investigate the incident really with the benefit of privilege, to avoid aspects of that investigation that will be highly sensitive and dealing with lots of different clients' matters, potentially are coming out in litigation. So I think having that privileged environment for the sensitive parts of the investigation is very valuable. I think that's true of any sensitive internal investigation. And so I think to achieve that, either in-house counsel who are advising on the matter or external counsel, will need to be involved at this stage. And I suspect external counsel will probably be very helpful for a number of reasons. I think, first of all, your insurers may well pay for it. So, get that extra resource that is covered by insurance. And also, if you've got a serious ransomware attack, actually your internal functions, your internal in-house counsel functions may be affected by that as well. In fact, they almost certainly are. So it's actually harder for them to advise and play that role, perhaps. So I think external counsel is extremely helpful, and privilege is something that's clearly desirable and should be sought to be achieved in sensitive areas. It is worth mentioning, though, that there is a twist on this for law firms, in that although there are potentially other regulators, we talked about the ICO, and maybe there are multidisciplinary practices who have other regulators, but the SRA is likely to be the regulator for most law firms. And as far as the SRA is concerned, well, they have special powers under the Solicitors Act. So they can require disclosure of privileged information from law firms. So I guess you have to also understand the limits of privilege in this particular situation for law firms. The SRA has pretty wide powers to require both disclosure of documents and also an explanation of what those documents mean. So I think that there does need to be great care taken, and I think probably specialist advice would be helpful to make sure everything is couched in the right way. That isn't to say there isn't benefit in privilege. Of course, it's relevant in terms of third-party clients. And of course, it does limit the SRA in how it can use that material. If the SRA requires you to disclose or to inspect privileged documentation information, it can only use that in connection with the investigation. So it does narrow the scope of what the SRA can do with it. So yeah, so privilege is important, and external counsel or in-house counsel should be involved, as well as the IT team. I think, as Arno said, it's also part of this, getting the business involved in the recovery and looking ahead.
Great, thanks, Dan. Next slide, please. So as we've seen with a number of data breaches, this is a newsworthy event. And the press seem very fond of printing stories about law firms and their troubles. And so security incidents are great sort of fodder for the press, both the main national press and also the legal press. And it does cause a myriad of issues, from potential reputational damage to client claims and obviously regulatory investigations in terms of the SRA and also the ICO. Next slide, please. So this is the last thing that you want to see your firm in a headline like this. Next slide, please. But Louise, if I could turn to you and ask what you would do in this situation now. So the fact that a firm has suffered a ransomware attack is now in the news. Clients will know about it. What should we be doing? What should the firm be doing from a crisis communications perspective? What would you advise them?
Clearly, you need a senior comms person on your goal team so that they are plugged into the incident team, and that person can then delegate and filter out, cascade information and to people who are going to be responsible for communicating to different audiences. So staff is clearly one important audience, the media is another, clients an important audience. The firm may even have funders. We're increasingly seeing the legal market. So we need to make sure that consistent information reaches those audiences, but that there are different people responsible for the channels. The media are obviously going to be baying for information. What we don't want is a vacuum, so that speculation kind of takes control, and that it runs away with you. It's going to be bad at the beginning, and I think that people need to realise that there is going to be bad press, but the best outcome will be to try and mitigate that and demonstrate that you're taking control. Often firms are judged by how they respond to situations like this, rather than the fact that the incident kind of took place in the first place. So there are three classic phases of crisis communication. At the beginning, it is fine to say we don't have all the information, so that we're working hard to establish the facts, we're investigating, we're cooperating with police, regulators, we're trying to understand the scale of the issue. And that will hold for a certain amount of time, but can't be your line forever. It will be important to try and give some answers to show that you're moving forward, that you are taking steps to talk about what you're doing, as and when you can say what percentage of client data has been impacted, or whether it's be specific about whether it's identity of client data, or payment data, or financial transaction data, medical records of employees, depending on the kind of law firm you are. It's important to give some detail, otherwise the speculation will fill the vacuum. But it is also important to only communicate on the facts. I think it was Talk, wasn't it, that gave out much more information than they needed to, and then they had to rein back, but the damage was already done. So you need to think about engaging an external crisis communications firm for two reasons, I think. One is that it can just help give you that external perspective and challenge any sort of bunker thinking. Sometimes the comms team will struggle to make headway with legal advisors, for example, on a gold team, but they can they'll take it from an external firm who have dealt with this kind of incident before. But you also might need a lot of extra resources, because it's going to be very intense for 48, 72 hours as you go through the process of trying to the tsunami of interest that you're going to have. So you need to write to clients, you need to call clients in some cases if they're important clients and their data has been compromised. You need to think about your website, having FAQs on there that are updated, and you need to have someone who's looking at the social media channel and directing social media responses to the website as well. So the golden rules are: only communicate on the facts, do say something, show that you're moving forward and keep updating the story, and try and be as transparent as possible.
Is there a difference between perhaps how you deal with the press and your strategy of the press, and then ultimately how you deal with clients? And if so, how does that how does it, what should you be doing differently when you're communicating with clients as opposed to dealing with the press?
Well, with clients, clearly there's confidential information. You need to tell them what you're to tell them what they should be doing and give them very practical information. The media obviously don't need to know the full extent, but if we give them nothing, then that will be unhelpful, and they will somehow be calling your clients and speaking to doorstepping people and finding out piecemeal information instead. So it's best to try and you need to give the media some details, the official line, but with clients you'll need to go into a lot more detail. You need to reassure them that you're on top of this and give them advice, because it may be that for example, that you're going to take an injunction, as we saw with the 4 New Square incident recently, that you're going to try and prevent their data being published on further. You also need to advise clients, if, for example, you're a law firm that has a lot of celebrity clients, then they will, the fact that their data might be involved is going to be more interesting than if it's a firm with data that no one's heard of. So there may be it may be that your clients are going to be doorstepped by media and ask questions as well. And if the clients can refer all the media calls through to yourselves, then that will help.
Great, thanks, Louise. So at this point, if it's broken in the press, Daniel, we need to start thinking about what we tell regulators, because perhaps even if we don't have a legal obligation, we might want to tell them anyway, because they're going to find out in the press. What sort of factors go into whether you actually have a legal obligation to notify, and I'm thinking the SRA here, the SRA in particular, and what typically do you need to tell them and when?
Yeah, thanks, Kolvin. So, I mean, I think Nigel's mentioned a bit already around ICA reporting, and the position with the SRA is, I think, somewhat different, and I think a bit more maybe convoluted. Nigel may disabuse us of that shortly. Yeah, I think you definitely need to think about your reporting obligations pretty early on, because the sort of the bar for making a report to the SRA as to what's going on is actually quite low. So before 2019, you just had to report where there's been a serious breach of the SRA's rules. And so that could basically allow you time to do that investigation, figure out what's going on, take a look at the code and work out what the report should say. That was, in the SRA's view, allowing firms to essentially defer making a report for too long, and also kind of allowing firms to act as the regulator, deciding when a breach had occurred or not. And so now I think most firms are now alive to this. The threshold for a report has fallen substantially, and really, so you both now have to report the serious breach in the same way that you did back before 2019, but you also have to report where there are facts that exist that might reasonably amount to a serious breach, or slightly differently, if there's facts that you think the SRA should investigate to establish whether there's a serious breach. And so if any of those sort of 3 triggers have occurred, then you're in a position where you need to make a report. And to be honest, in a ransomware situation, I think it would be hard to envisage a ransomware situation where you're not going to fall within one of those three categories, to be honest. Now, the current code of conduct is fairly sparse and does take a bit of interpretation as to what exactly a rule means, and then a bit of interpretation as to what is a serious breach of that rule. But there are clearly obligations in terms of client service, confidentiality, and that you have proper systems and controls in place to manage risks. And I think you could almost say by definition your security systems have been breached. There's going to be a risk that this is because of some kind of issue with the firm. It sounds quite harsh, because really the firm is the victim in this. They're the victim of a criminal attack. But it could be an inside job. It could be that you left effectively in the IT world equivalent of leaving the front door open and unlocked because you didn't patch your systems properly, and so on. So I think the idea of having to make a report it's pretty unlikely that you would not have to. But then the question is as well, when and what do you put in it? And the answer is to that is it depends. The obligation is to do it promptly. What promptly will mean will depend on the circumstances, but it doesn't mean immediately, which is why I think when we were in phase 1 or 2, we sort of said, look, that's not the point at which you tell the SRA. You do have an opportunity to at least understand what's going on, to work out whether or not there has been this serious breach. But it's definitely not something you can sit on for weeks. It's something that you need to think about in the early days of this. And in terms of what you have to say, well, you can give an interim report. This is probably only step 1 of your interactions with the SRA. And we'll come on a little bit later, I think, onto what might happen next.
Nigel, anything to add from a ICO perspective? That's a little bit more prescriptive, I think.
Yeah, indeed. Well, as we talked about before, the GDPR requires that data breaches may need to be notified to them. And basically, it will need to be notified to them unless it's unlikely to result in a risk to the rights and freedoms of natural persons, using the language of the GDPR. So the requirement is based on a risk assessment, and also the requirement to notify the affected data subjects is also based on risk, but there's a much higher bar. The test there is whether the data breach is likely to result in a high risk to the rights and freedoms of the natural persons. And the time frame is also slightly different for notifying data subjects. It has to be done without undue delay, but not necessarily within the 72 hours. So you might have a bit more time to consider that. So it can be that because of the different risk assessments, it could be the case that you have to notify the ICO because that's a pretty low bar. But you don't necessarily always need to notify data subjects who've been affected if you can assess that they're not in a high risk. So in making this a risk assessment, you've got to take into account the various effects that the data breach may have. That could be loss of control of their information. It could be if there's a risk of identity theft or fraud or financial loss, or it could be damage to reputation, or simply loss of confidentiality, loss of information that should be subject to the professional duty of confidentiality. Also consider the sensitivity of the data. Do you have special category data involved? Does it include sensitive data like payment cards or bank details? So cases where notification may not be necessary could be, for example, where the data was encrypted and the decryption key was not compromised. So in that case, you may be able to say that the confidentiality risk was reduced. Also, if the availability of the data has not been compromised. So if, for example, you were able to mitigate the effect of the attack in short time by restoring from a backup so that people were not compromised in any way. On the other hand, the picture would look very different and notification would be required if the backup data was also encrypted, as Arno said sometimes happens, or if restoration of the data is going to take some time, or if the data was unencrypted and was extracted by the attack so that confidentiality was compromised, or if there's a large amount of data, a large number of data subjects affected, including sensitive data or special category data. So in any of those cases, inevitably notification is going to be required. In terms of how you actually make the notification, it's pretty straightforward. The ICO has an online form. It's a relatively user-friendly form to do, but it does require quite a lot of information, some of which you may not have. But as Arna's commented, you can make the initial report in time and then do a follow-up report once you've got more information following your further investigations.
Right, thanks,
That's going to add, and that's what's very important. The forensic investigation will be providing the evidence to the legal team to make that justification, because we've been talking about ransomware in a situation where it encrypts data and denies access to it. But in the last 6 months, we've seen several new strains of ransomware that actually takes the unencrypted data, makes a copy of it, so steals the data and then encrypts it. Essentially, the criminals trying to get more bang for their buck,
right?
And by trying to steal the data. Clearly, that if we discover that in the evidence and in the signatures of ransomware, that'll have a big impact on any notification obligations.
Yeah, no, absolutely. And this is where the legal team and the IT team need to work in harmony, because often it's the legal team saying, well, this is the information I need in order to make the risk assessment that Nigel talked about, and also prepare the various notifications. So Dan, if the IT team are unable to restore the systems, and Arno mentioned this, that in a lot of cases, the ransomware actually gets paid. What does this look like for a law firm? What are the kind of legal implications for that? Clearly, there are some reputational issues, but what about the legal implications as well?
Yeah, so of course, of time. So very briefly, really, fundamentally paying a ransom is not illegal unless you are aware that the criminal is engaged in the pursuit of terrorism or subject to a sanction, essentially. So it's not really so much often as a legal question, but as a reputational question, as you say. Law firms paying criminals doesn't look good. And although the SRA has yet to really take a firm view against it, you could imagine that if law firms become, routinely in the business of essentially funding criminality, then that is, I think, both reputationally a problem, but also an issue in terms of the public trust in the profession. So I feel that this is something which, as sadly ransomware grows, may become less available as a means of resolution. But as things stand, if you're insured, there is the possibility the insurer will pay. As I mentioned, the insurer may well pay the ransom, but it does carry some risk.
Great, thanks, Dan. Next slide, please. Okay, so we're into the sort of, I guess, the initial final steps or initial conclusions. So Arnold, from your perspective, the situation is now mostly under control. What would you be doing, or directing your IT team to be doing, from a sort of final remediation perspective? And I think we are running out of time, so if you could just keep it to a couple of minutes, that would be great. Thank you.
Really quick there. That's very important that we now have IT working with the cybersecurity experts, because the investigation will likely be ongoing for weeks, if not months. Whilst at the same time IT need to recover, and it's a balance between being able to operate and keeping the right evidence. I think something we've come across a lot, a very practical thing that sounds silly, but have a real careful look at employee holidays. Sometimes both the recovery and investigations lose time because employees, particularly with big global firms, go on leave. Critical people need to give access to systems or help us get to certain bits of evidence, then become unavailable, and that becomes disruptive. I think in addition to the recovery and the investigation, a very important part that people glaze over and jump over too often is the lessons learned. So to take the time to focus on how could this have been handled better, how could we have prevented it, so what future improvements are we going to make, and then critically document that and communicate it, as Louise was saying, both internally and externally. That creates confidence. There's no such thing as perfect cybersecurity. It's not a matter of if you'll be breached, but when. And I think the regulators get that, and the public get that. So if you can show that you had proper duty of care, you handled it appropriately and correctly, and you're taking the right lessons learned afterwards, that could leave the company in a very strong position.
Thanks, Arno. Nigel, Louise mentioned that I think one of the barristers' chambers took some action in terms of two potential actions. One, injunctions to stop the further disclosure of information, but potentially also to recover ransom fees. Is there any other, what sort of legal actions would you see potentially coming out of a ransomware scenario?
Well, much may depend on the facts of the particular case and what led to the ransomware getting onto the network. So But if, for example, the attack got onto the network as a result of some failure or lack of security in network maintenance, which you'd outsourced to a third-party provider or vendor, then there may be a claim against that service provider. So if, for example, the operating systems or applications were not patched up to date or with latest security fixes, or if backups were poorly configured, then in those sort of cases, you may want to dig out the contract you've got with a service provider, look at the scope of their responsibilities, and also look at the limitation of liability provisions. And that may be a time when you regret agreeing to the vendor's standard terms and conditions, because they likely contain extensive limitations on their liability, which may not cover all of the costs and losses involved. Often, for example, standard contracts specifically exclude liability for loss or damage to data. So one lesson is not to accept such an exclusion where the vendor has responsibility for keeping data safe.
Thank you, Nigel. And Dan, we've done our initial notification to the SRA. What sort of further engagement could we expect?
So the SRA, when they receive that initial report, they will acknowledge every report, and then there's usually sort of a period, and it's quite a long period, because although you're under obligation to report things promptly, the SRA is under no obligation to investigate things promptly. So right. it can be some time, even after everything has been resolved, that the SRA then comes knocking and starts asking you the questions. So be prepared for that. But assuming that you can demonstrate, probably by a further report before they even get in touch with you, that you've taken the appropriate mitigating steps and that you've recovered, then hopefully that will be the end of it. And ultimately, they will just hopefully give you the report that matters are concluded, and here's our advice on cybersecurity. Thank you very much. That's the ideal outcome. Clearly, if they think there's questions to be asked, they will ask those questions, usually over a very long period of time.
Thanks, Dan. Next slide, please. Okay, so just in the last couple of minutes, just going to outline some key steps to prepare. Next slide, please. So key with every incident, I think Arno mentioned this, is to have a plan. So to have an incident response plan. But as Mike Tyson once famously said, everyone has a plan until they get punched in the mouth. So the key is to practice the plan, and practice, and that's what simulation exercises are designed for. And there are various external. You don't necessarily need an external company to help with this, but there are various external companies that will help you with a simulation exercise. And I would say the other thing to emphasize is that make sure line up your team beforehand. So make sure you know who to communicate with you in the event of an incident. And this should form part of your incident response plan, but you need to make sure that that is up to date. I think Arno also mentioned this as well, is around having an IT contingency plan. Again, should be part of your IRP, but is more IT focused. So thinking about what will happen when systems are down, making sure that you have good, tested and offline backups. So that is the end of the session. I think we're almost perfectly on time. So I want to thank our panelists, Daniel, Arno, Nigel and Louise. We hope you enjoyed the session. Thank you so much for attending, and enjoy the rest of your day. Thank you, everyone. Goodbye.